get one person demanding a large sum of money, rupees 8 lakh, a multi-car, air conditioner, television, etc., etc. So we should be thankful for this lady because she filed this case, and then by that her filing, because it's a false case, and then the person get arrested. So when they get arrested, they moved to the Supreme Court, and the Supreme Court has passed this decision, which is known as, and that man is Amnes Kumar, and it's a kind of state of Bihar and against that lady. So it was reported in the Supreme Court, which is a very interesting case, which I would like to share with you because nowadays you have seen that so-and-so was arrested, it was given the newspaper, and after a few months, nothing come out. But what happened to that person? That person was humiliated in front of society. Everybody who read the newspaper have seen that the so-and-so has been arrested. But ultimately what happened? They become big zero, nothing come out. Because the case has not come to a logical end. So now I will read only the relevant portion because it's lengthy. So the Supreme Court has decided in this public case of dowries like this, bring humiliation, courtly freedom, and caste forever. Lawmakers know it, so also the police. There is a battle between the lawmaker and the police, and it seems that police has not learned its lesson. The lesson implicit and embodied in CRPC, it has not come out of its colonial image, despite 6 decades of independence. It's largely considered as a tool of harassment, oppression, and surely not considered a friend of the public. The need for caution in exercising the drastic power of arrest has been emphasized time and again by courts, but has not yielded the desired result. Power to arrest greatly contribute to its arrogance, so also the failure of the magistracy to check it. Not only this, the power of arrest is one of the lucrative sources of police corruption. The attitude to arrest fast and then proceed with the rest is despicable. They have become a handy tool to the police officer who lacks sensitivity or act with oblique motive. Law Commission, Police Commission, and this court, in a large number of judgments, emphasize the need to maintain a balance in individual liberty and social order. Individual liberty and social order, which, while exercising the power of arrest, police officers make arrests as they believe that they possess the power to do so. As the arrest for material freedom bring humiliation and cast scar forever, we feel differently. We believe that no arrest should be made only because the offense is non-bailable and cognizable, and therefore lawful for the police officer to do so. The existence of the power to arrest is one thing. The justification for exercise of it is quite another. Apart from power to arrest, the police officer must be able to justify the reason thereof. No arrest can be made in routine manner, and a mere allegation or commission of an offense makes against a person. Prudent and wise, but police officer, no arrest is made without reasonable satisfaction, despite after some investigation as to the genuineness of the allegation. I'll go straight to the decision. Then the Supreme Court lastly said that we are of the opinion that in provision of Section 41 CRPC, which authorizes the police officer to arrest and accuse with an order from a magistrate and without warrant, are scrupulously enforced. The wrong committed by the police officer intentionally and unwittingly would be reversed, and number of cases which come to the court for crime among enters will be substantially reduced. Then the Supreme Court has further added, our endeavor in this judgment is to ensure that police officers do not arrest accused unnecessarily and magistrates do not authorize detention casually and mechanically. Order to ensure that we have observed work to give the following direction. All state government instruct police officers not automatically arrest when the case under Section 498A. 498A is a dowry. So now, all over India, straight away the police will not arrest in case of dowry. All state government instruct police officers not automatically arrest when the case under Section 48A or ICFAI is registered, but to satisfy themselves, about the necessity for arrest under the parameters laid down above, following from section 41. And lastly, we have stated that we hasten to add that the direction of aforesaid shall not only apply to the cases under the section 498A of the IPC, that is dowry, or section 4 of the Dowry Prohibition Act, the case in hand, but also such cases where offence is punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine. So this shall apply to all the offence, not only to dowry offence, but to all those punishable with imprisonment for a term which may extend, for a term which may be less than 7 years or which may extend to 7 years, whether with or without a fine. In the affair of the running of the state to come forward to implement or to enforce this law. So with these few words, I thank the organization for giving me this opportunity. I thank you also for giving patient hearing, and I do hope and look forward that we will be conscious to our right, and at the same time also for students also to be fond of reading the act, even from time to time, which involve the social justice. As a matter of fact, the majority of the law in India are social justice, as laid down in the Constitution of India. But the only thing is that numerous cases are in respect of the Indian Penal Code and the procedure laid down in the CRPC. Otherwise, there are many laws regarding social justice. So you see, you have to read the Food Corporation of India Act also. That act also, if you go through how the food is distributed, mere complaining, mere criticizing will not help unless we come forward to eliminate the evil in the society. So we have to come forward to enforce the law. Thank you.
Listen to the presentations of all the panelists, and at 3:45 p.m. as per the original program, we are expected comments of the moderator and not comments by or from the moderator. So I take this opportunity of the grammatical mistake in the program, and therefore I'm not going to give any comment. You have listened very attentively, and therefore I'm not going to add chilies to the sambar provided to Mr. Lim. What I'll do, I'll try to cut my comments, if there are any, as short as my height itself. And therefore, I know many of you would like to come or even jump to the program at 4:48. That will be better than many of the speeches that I have today. 2-3 years ago, I read a piece in the Telegraph, which was written by Anuradha Roy, where Mr. Roy referred to the Swedish writer by the name of Henning Menkel. And Henning Menkel worked among the people of the civil war-torn country of Mozambique. As reported, everything in Mozambique, because of the civil war, and because not only of the civil war, but because of the long civil war in that country, had been burned and destroyed. One day, as Mr. Menkel walked through that scorched wasteland, he saw a man approach from the other side. Now the man was starvation thin. Obviously, he did not have food for many months. And most of these poverty-stricken people of Mozambique, which Mr. Mankel had seen, they were not able to have proper clothes. They put on rags. Yet when he saw that man approaching him, he saw that man was wearing shoes. It was only when the man came much closer that Mankel realized those were not real shoes at all. In order to conceal his wretchedness, the man had painted the shape of shoes onto his feet. Therefore, if we try to learn from this story, I am afraid that what we call social justice, or the other concept that is very much current these days, especially in India, is what they call positive discrimination. Now, if you take from this story, the concept of social justice or the concept of positive discrimination, to many underprivileged people of India, these privileges, whatever kind of privileges that we have had, the acts, the rules, the regulations that we have heard from the panelists, these were actually painted as the shoes of that person from Mozambique. And these painted shoes have been painted into our feet in order to feel that we have been protected or we have been given social justice. And therefore, with the plethora of these acts, rules and regulations, sometimes we feel that we are able to find or we are able to get some kind of social justice. In fact, as Dr. Hasina has mentioned, we have not even reached near that stage, and as the others also have mentioned. And friends, therefore, when we go out of here, out of what you have listened from the panelists, try to think of not only of those painted shoes, but try to find the real shoes. Of course, don't go to Bata shops, but go to what the last speaker said, the acts as provided by the Indian Constitution. And in this way, therefore, we will be able to know about our own rights. And also, we will be able, of course, to put questions about our own rights and how we can enjoy social justice. Now, friends, as I said in the beginning, you have anxiously waiting for your opportunities to interact, unless you want to immediately jump to 4:48 p.m. And as a teacher, I used to tell my students, if you are not clear about some concepts, if you have doubts in your mind after listening to your teacher, do one thing, ask questions. If something is not clear to you, and you don't ask, or you don't try to find a clarification from your teacher, you remain a fool throughout the rest of your life. But if you ask a question, and you get the clarification from your teacher or from the members of the panelists that we have today, you remain a fool only for 5 minutes. So the choice is yours. You want to become a fool for the rest of your life, or you want to become a fool just for 5 minutes. So therefore, since one of the members of the panelists, Mr. Himalaya, is not here, we still have a little more time for you to ask questions. Please come forward and ask these honorable members of the panel questions that you would like them to address, which are the issues which are not very clear to you. Thank you very much. So come forward and ask.
Or the person who is recipients of that may make law. Is that your question?
Yes, sir.
Right, thank you.
Yes, sir. May I request Mr. Kanjing to reply to that?
Your question is that you went there and the organization, you mean the so-called NGO.
When I was in Nepal,
Give an illustration. Give the illustration.
example, my example is, I've experienced when I was in Nepal, I was trying to get, because I was in a hurry, I was trying to get a cab from the highway only, but those people from the stands, they're not allowed. We have to take from that stand only.
As per the queue.
Yes.
That is the queue that means. I think no law is involved in that. That is an arrangement made by them only. It's a part of a trade, I think, among them. Trade or occupation. I do not think that any law is involved in that. So how to enforce things? You see, things can be enforced only when there's a law. Yes, sir.
Can I answer that? I will say
They are wrong, but the problem is that how you enforce it. Not that they are in the wrong, but how to enforce it. That's the thing. It is not as simple as it appears to be. Yeah. Because you have to file a complaint to the police, wrongful arrestry, something like that, obstruction, wrongful arrestry. Yeah. That is a part of life, I think.
I think to what I understand this question is, nowadays they have a lot of taxi associations, sumo different associations, and they have a control system on getting passengers, whether you are in the airport or you are in a taxi stand like Nongport, because I go to Umden quite often. I understand what you're saying, is that to ensure that they have the passenger as per their time, they have like which car is number 1, number 2, number 3. So they feel that if people takes the car by specific, then the one who's been waiting there for a long time is getting a passenger. So that is basically to ensure that the car who just come very quickly should not get the customer. So that's also an issue which they're trying to streamline nowadays. Of course, it's not done properly. Sometimes they become a little bit, pressurized. They pull out passengers from a car and they say, now get into that car, which they do in the airport. Or either the Meghalaya car in the airport has to pay 200, like a penalty if you want to, leave the car early. So I think these are something which will need to be streamlined, and I think the Darvashnam of each of these things can really bring those kind of, organized associations so that they function properly. Or demarcated, like what Thomas said, which are the places they should take a car and what are the procedures. Unless sometimes they pull out customer, I've seen that.
Yes, any other question?
when the plan
I'm just confused about the I just like the opinion from the panelists on the customary laws. The customary laws, it's not written, it's not there, but yet our customs we tend to follow. Some of the customs basically I personally believe that we should not follow anymore. There are some customs that we have to follow, but there is no written law about, there's no customary laws that is written as yet. But then it's debatable whether those customs should be followed or not. I just want your opinion from the panelists about the customary laws.
Now, I think it's got two parts. One is how we see from our discipline, as I said again, and the other, I think, how the judiciary will see it, because it's two. In our discipline, probably in social anthropology or sociology, we try to avoid the word law, because the moment you say law, then it deals with the modern state. So we will always say customary beliefs and practices. These are beliefs and practices, and how these beliefs and practices have been carried out and followed over generations. You know? Yeah, as you're saying that, we may want to challenge. We may want to challenge some of the practices. But if you take in the case of India, again, you have the Constitution of India, which has also recognized in the 6th schedule customs. It has also recognized that as part of the customs, except that if the people themselves, okay, not just an individual, the collective, if at the level of the collective, that the collective decides that, okay, with regard to these kind of customary practices, for example, one of the most interesting examples I always cite in the case of Mizoram. It was the Mizo community themselves decide that we shall do away with the siloship. That is the chieftainship that used to be there. They decided, and they just finished it in one decision. But it was not a decision of one or two people. It was a collective decision. Then you can talk in terms of applying some other new laws. But it is not that easy. If you see, for example, the debate on matrimony itself, there are these organizations that says, well, we are not agreeing everything with matrimony, and therefore we would like to promote something different, which is neither matrilineal nor patrilineal. It's neither one or the other. It's a new kind, but we don't know yet. As I said again, it's difficult. But the points that I want to address, how from the law part we would like to address that. But from the side of us, unless the collective decides, it is difficult to remove or to do away some of the beliefs and practices, whether in terms of inheritance, whether in terms of rule of descent, whether in terms of other matters concerning social life. It is difficult unless the collective. It has to be a collective decision. Or for example, in the case of the Nagas, the practice that is to have, it was the external. It is to have a practice what was called headhunting at that period. It was Christianity. It was the missionaries who helped them to start taking decisions. And they took a collective decision that this practice is not okay. So they did away with that. So that collective decision, I think, is the key to whether you would like to preserve some of the practices or you would like to do away. So the answer to me is with the collective. Maybe from the law, I don't know how you can see it.
This council, under 6th schedule, social custom is given to the district council, all the district council. And right now there is no codification of the custom of the tribals. They are trying to do, of course, Khasi is doing, Karo is doing, but now, of course, there are, due to some cases, there is an objection regarding Karo, so it's like that. Otherwise, there is an attempt by the council, endeavor by the council to codify the social custom of the so-also the Khasis. So it depends also as far as regarding the election of headman, chief, and other, for that codification or mostly have to do that.
See, this question raises of immense interest. Why are you asking that are customary laws still relevant? These laws must have been relevant at the time they were made. At that period of time, they must have meant something to the people who made them. You are asking this question today because something at the back of your mind leads you to believe that I need to question whether these customary laws are still pertinent or not. So actually I think it is a trauma that you are facing because of the change, a change. We are facing change and it is very difficult to adapt to change. It's very, very difficult, especially in social customs. It's very difficult. We try to hang on to, since for us basically as tribals, custom and tradition and culture is so important. And this custom and culture comes back from our ancestors. But how do we change? And if we change for what? As per the dictates of time. it's very, very difficult. It's very difficult. Today, when we find, especially, I'd like to go back to what Karam was saying about maternity. The Qasis, let me speak from the point of view of a Qasim. The Qasis had one of the biggest, largest joint families. It was a joint family system. Everyone enjoyed it. And it was headed by the matriarch. But then suddenly today, we find that Qasi families are becoming nucleus families. It's the father, the mother, there's no such thing. The uncle has the least to do with my family. It's me and my wife who are looking after our children, and about my wife earns, I earn, I don't depend on anybody. So then this whole customary law again, of doing anything and asking the advice and the leadership of the uncle. A lot of Qazis are questioning this today. Do I really need that? What is the custom? I mean, just an example.
I'd just like to add, we have done a research called Access to Justice on 6th Schedule area, and that was done for the Department of Law and Justice Government of India. And this is looking at justice delivery system in Meghalaya, Mizoram, Nagaland and Tripura, not the plains, where 6th Schedule is still pertinent. It's very interesting because we could hear our panelists giving their observations about the changing time. But the question of how constitutional rights, women's rights issues, child rights issues, at different stages today is coming in conflict with customary law and practices in many places, not only in Meghalaya, but many, many places. The biggest debate is whether we codify. that research report is available in our website, you can download, it's released, and it's actually giving a roadmap, and in fact Patoki was also one of we had interviewed him also for that entire research work. So the question is whether we codify or do we document? That was the two aspects that evolved from a lot of the people we interviewed as open-ended and also as in-depth interview. And the findings came in is that they are the good side of customary law, which has not been documented, but has been actually practiced. Because as what Rahman was saying is a practice and belief. But then there are some customary law in certain places, like for example in Nagaland. It's very interesting that till today, in many of the villages, when they have to deal with rape cases of women, they still are, practicing the customary laws in giving decision. If a woman is raped below the road, it's considered rape. If a woman is raped above the road, it's not considered rape. And why did they say that? They said that below the road she can fight, but above the road, that was framed long in ancient time. But the practice is still there. So the biggest question today, I'm just giving you one example. The biggest question today is we are talking about women's rights. Our right, where we have constitutionally. Now, I'm supposed to go to police station if something has, if my rights has been abused, whether I've been raped or I've been, I've been molested or any of that. But in a situation, for me in urban context, because I'm aware, because I have the education, I have the, the services. But for somebody who's in a village, deep village, because the community is still practicing that, they will still go and refer that case to the Gaubura, as they call it, or here as a traditional institution. So in that situation, if customary law is strongly practiced, the beliefs still strongly practiced, the woman's right is not, available there, because they will give the judgment as per that. And we had documented those research work, which is very, very interesting, the conflict of constitutional right and the changing of laws, and the awareness and the practices which is happening in the ground. So this is quite a big debate right now, because this research is telling, do we do for codification? If we codify, I think we have somebody from the judicial here would say that it becomes a law. Or do we document to ensure that there is uniformity of how judgment are being given in different villages on the same issue. And when we did some piloting of documentation, we saw village A and village B did not give the same judgment for a particular issue. It all depends on how ancestral they've understood, how they would take forward. Yeah, in land issue, it's very interesting that the customary law is very good. You don't have to go to code of law because the boundary is an issue. But in women's right, in rape, in molestation, these are changing aspects which I think it can still be debated, but of course there are procedures of how things can change.
to, this is the question of tradition, modernity dichotomy. We have not been able to do away with our customs, we have not been able to do away with all our traditions. We do keep some of them, but also at the same time, we have not been able to adapt totally to the changing situation or to adapt ourselves to the constitutional institutions. So we are somewhere in between. And that's why I said it's a dichotomy between traditions and modernity. And in such a situation, of course, a section of the people, they prosper on this. And they make a lot of money because of the interpretation, misinterpretation, over-interpretation of this. And because of this, therefore, some people, they want this kind of a situation to continue. And it will be a headache, of course, for Hasina. But she will not be able to find the reality of the situation. So, as long as we try to keep both these together, it will be very, very difficult to come to a conclusion or to decide anything.